Good morning.
Morning.
Good morning.
Morning.
Your Honor.
Morning, Your Honor.
Morning.
Got a pretty big group here today. We're going to try and get through this as quick as we can. I already reviewed the calendar. I know there are a few things that will take a little bit more time than others. Some of it's just announcements and figure out where we are. Starting with the first position, Timberlake versus Lefkowitz and Gaben Properties. Who do I have here on behalf of the Timberlakes?
I do not see them, Your Honor. This is Lauren Meadows, counsel for the defendants.
Right. And I know they were having some issues. They had reached out. I think Mr. Freehoff would have copied you on that, but they'd reached out for my assistance in making sure they had everything from their old attorney. And their old attorney assured me that they did. And so I don't know what steps they took from there. But I do know that they understood they were required to be present here today. But we'll wait and see if maybe they log on. Did I notice that their depositions were set for February the 21st? Did they appear?
They occurred yesterday, Your Honor. Yes, they did appear yesterday.
Okay, thank you. So Ms. Meadows, if you will sit tight, we will just wait and see if the Timberlakes join us, okay?
Sure, thank you.
Thank you. If anyone is here on the DOT versus Abbott's Bridge Place, my apologies. I don't understand what happens sometimes in EFAL, Georgia. You attorneys probably sympathize. But we issued a notice well after all the attorneys had appeared in that case. And for some reason, that notice did not generate service notices to those attorneys. And so if you somehow did get notice, because we were contacted recently by a couple of the lawyers, that matter has been reset. And Mr. Freehoff has reached out to the parties as to what, if any, scheduling order they want before it goes back on the calendar. So if you're here for that one, you're free to go. Next up is Boy Wonder versus Brickcell Investment Group et al. I see Mr. Mzikawe. And do I have Mr. Yaklin?
Ethan Pugh here for the
Hi, Mr.
co-defendant and third-party plaintiffs.
Okay. And okay. I have received y'all's CPTO. I'm aware of the motions that are pending, so I'm gonna come back to y'all in a few minutes since I know we have everybody here. Quotum Technologies versus Daryl Green. Who do I have here for that one?
Good morning, Your Honor. Mark Oakes for the plaintiff.
Okay.
And we settled that last night.
Oh, excellent. Love that. Thank you so much. Are you guys, do you need some time to get the paperwork done before you would actually file a dismissal or anything? Is that correct, Mr. Oakes?
Yeah, that's correct. We've agreed in principle to the terms, but we're trying to memorialize those in the settlement agreement right now. And as soon as we do, we'll have that signed and we'll dismiss the case.
Okay. Can you, for my benefit, would y'all, if y'all are comfortable doing so, would you please file a notice of settlement that just notes it on my record as a, that this case is settled and we're just waiting for the paperwork? Because that's what tells Mr. Freehoff, follow up with these guys in a few weeks and find out if when and how they're going to file a dismissal.
Yeah, unless Mr. Bushnell objects, I have no problem with that, Your Honor.
No
I think I
problem.
saw him nod, so excellent. Thank you, gentlemen, both. I appreciate it. I will note it down. I will look for your notice of settlement, and then we'll look for your dismissal when y'all are ready to put that on paper, okay?
Appreciate it. Thank you, Your Honor.
Thank you both. Have a good day.
Thank you.
After Nine Partners versus MetaWorks. Who do I have here on that one?
Frank DeMelfi for plaintiff.
Hi, Mr. DeMelfi.
Good morning.
Do I have anyone here on behalf of MetaWorks or Gallagher? Mr. DeMelfi, had you been in contact with them? Were you expecting their appearance?
Yes, Judge. It looks like Mr. Yehuda is in the lobby. I'm not quite sure if he's having audio problems.
Yes, Your Honor. I'm sorry. I've been here the whole time. It's just I had to step out and handle something. I'm sorry about that.
No, I understand. Zoom is often an interesting exercise in multitasking. Okay, so but you're here now, and that's what matters, Mr. Bruck. Okay, so I have not received a CPTO from you guys. There are no motions pending. Perhaps y'all could help me understand why y'all filed a jury demand jointly, why it matters to the setting of the trial calendar, particularly given that there was a jury demand made in the complaint. And this is set on a jury trial calendar. I'm also aware that y'all asked to reset the matter. But the case has been pending since 2023, and basically y'all may have been doing lots of things in the background, but there's no indication on my record that anything significant's been happening. And so I'm struggling with why we're just now getting to, we're going to go have a mediation, and can you please extend this for, I think it was 3 or 4 months that y'all asked for.
Judge, if I could, for the parties begin. So the reason why we filed the joint demand for jury is because I believe, unless I mistakenly read on the notice of trial, it said non-jury calendar. So we just thought,
No, I appreciate that. And if that's what it said, but the fact of the matter, we try to identify them as jury, non-jury, but at the end of the day, my civil trial week is March the 24th. So it doesn't matter either way.
Absolutely fine. We just wanted to, we were doing it out of an abundance of caution, just to make sure that we had it
Belt
on
and
the-
suspenders, always good, Mr. DeMelfi.
Absolutely. And then, so look, Judge, this case was a little interesting. When we very first, just to refresh your recollection, when we very first served the case, the defendants had individually had some difficulty finding counsel because they're out of state. And so we extended the case for some time, the time period to answer. So it's set for a few months, and we got Mr. Bruck on the case, and we've been discussing the case pretty regularly and trying to come to a resolution. The parties, I don't believe the parties, it's in their best interest to litigate the case they're trying to settle. We have big personalities on both sides of the equation, and despite our efforts to try to mediate the case together with counsel, we just think it's going to be a good idea to have a neutral in the room to get these guys in, even so much as though we also agreed not to do a Zoom mediation, that we want it in person. We want to get the guys down at the table to iron this out. Because there's a counterclaim and it's really, there's a plaintiff's claim and a counterclaim, and they're both kind of pointing fingers, and we're just trying to get to the meat of it to try to figure out where it lands.
And is the mediation actually scheduled for a date?
Yes, we've selected April 30th as the date. We have to select a mediator. I've proposed a couple of mediators to Yehuda, and I'm just waiting for his feedback. He's just scoping them out. He wasn't familiar with the Georgia Association or National Academy of Georgia Mediators and Arbitrators, but turned him onto that and gave him some names, and just trying to find somebody with availability for an in-person.
Okay, Mr. Bruck, thoughts?
I have nothing to add.
Okay, so I guess that does indicate y'all are getting along well, Mr. Bruck and Mr. DeMelfi.
Yes.
So here's what, all of that sounds reasonable, Mr. DeMelfi, and I'm not going to make the parties litigate something that they think they might have a shot at resolving through trial. Here's what I would ask: if you guys can get a date and a mediator and notify the court that, and you need to do this in the next week-ish, but if you need to do it before March the 24th. But if you can tell me that you have a hard date for a mediation with a mediator and notify Mr. Freehoff of that, then we will remove this matter from the calendar. And I know that what you actually filed was a motion for stay. I don't know that one is necessary because all of the deadlines are there's nothing for me to stay other than the trial date. And so what I would do if I get that confirmation of an actual scheduled mediation with a mediator is just reset the matter to the May calendar, which would be the end of May. You would need to appear the first-ish week of May to let me know if you are going to trial or have settled. But you wouldn't be expected to go to trial until a month after that April 30th date if the case has not resolved. Can you all live with that, Mr. DeMelfi?
Yes, Judge, that's fine. Did you want something on the record filed or just an email to Mr. Freehoff?
No, just an email to Mr. Freehoff is fine. Mr. Bruck, is that fine with you? I think I heard the beginnings of yes. But if not, Mr. Bruck, let me know. But what
Yes,
we're gonna...
yes, Your Honor, that's
Okay.
fine.
Okay, excellent. So the two of you may be excused. I will look for your information about a hard mediation date with an actual identified mediator. And once I have that, I'm going to reset this matter to the May trial calendar so that y'all can let me know if you have a resolution or that you can go to trial in May, okay? Thank you, Mr. DeMelfi. Mr. Brock, you're
Thank
free
you,
to go.
Honor.
Thanks, Judge.
Have a good day.
You too.
Choice Financial versus HPE.
Good morning, Your Honor. Bradley Singer for the plaintiff.
Thank you, Mr. Singer. And who do I have here on behalf of the defendant?
Good morning, Judge. Bridges Rowland for HPE.
Okay,
Your Honor, the case settled yesterday. We can file a notice of settlement. I have sent the paperwork over and we just need a few days to finalize.
excellent. Thank you very much, gentlemen. I always appreciate that announcement. So as you heard me say a moment ago, if you can just in the next few days file a notice of settlement so we have a placeholder, and then we're happy to give you guys several weeks that you need to get whatever reduced to paperwork and then file a dismissal or whatever it is that will resolve the case. Does that work for you, Mr. Rowland?
Yes, ma'am. Thank you.
And you, Mr. Singer?
Yes.
Excellent. Thank you so much, gentlemen. I will look
Thank
for
you.
your notice of settlement.
Have a good
Thank
day.
you, Judge.
Thank you.
You too. 4370 Perrin Place versus Cameron Buckler.
Good morning, Your Honor. Yasha Haderi on behalf of the plaintiff.
Good morning, Your Honor. James Johnson here for the defendant.
Okay. So I am aware, so I have this on a non-jury calendar. And I am also aware that the plaintiffs have recently filed a motion for summary judgment, which I had to do math for to figure out if it was timely, because my own personal pet peeve, I did it to myself, which was put a deadline on a weekend. And of course, that weekend happened to be followed by a holiday Monday. And so there was all sorts of weird lawyer math I had to do to figure it out. But it was, in fact, a timely motion for summary judgment. And then also, I see that the defendants filed a motion to dismiss for various and sundry reasons. Where are we on this case, and what do we need to do with it, given that I don't think the motion for summary judgment is yet ripe in terms of the defendant's ability to respond to it, and vice versa for the motion to dismiss, though that date will come prior to the trial date that's currently March the 24th. What are your thoughts, Mr. Hadari?
I actually spoke with Mr. Johnson about this, and we're both sort of on the same page. And so we would ask the court to issue a ruling one way or the other so we know what's coming, and that will dictate how this case plays out. And I think that having a little bit of foreseeability would be good for all parties, instead of a morning ruling and then knowing that we have to fly people in for Monday for a trial or something along those lines. So I think we would both request a ruling prior to actually scheduling this down for trial one way or another.
Okay. I certainly, y'all are entitled to do that. That's a reasonable request. Mr. Johnson, what are your thoughts on that, sir?
I second that. Basically, I've been in this case for a week. Mr. Buckler just hired me, and what I came into knowingly was a summary judgment motion pending, and the summary judgment motion is based on an alleged failure to respond to discovery. My client says he never got it. There are some issues with that. And so what I need to do over the next couple of weeks is do the discovery responses, move to have admissions deemed not admitted, and then respond to the merits of the MSJ. And as Mr. Hadari says, I think the appropriate thing would be to hash out the MSJ on the merits. And then if there's to be a trial, set it maybe on your May calendar, because I've got a client from a small village in Canada, and I don't know that I could turn him around between the time that you rule on the motion before the 24th and the beginning of the calendar on the 24th.
Okay. Hang on just one second. I'm trying to open this file because I wanted to ask about, so this action was filed back in 2023. There was an amended scheduling order that was entered at one point based on a prior trial setting in September. I think the trial was actually set for October of 2024. And then as a result of that, there was a continuance, and I think prior counsel for Mr. Buckler was allowed to withdraw. And then, you know, now we're here. And I have not, certainly Mr. Hidari probably knows the facts of the case better. Mr. Johnson, certainly both of you know the facts better than I do, but it seems like a case that we could resolve or get tried fairly promptly. It doesn't seem like it's a case that would take a particularly long time to try. Mr. Hidari, if I do, I believe the deadline for the summary judgment response is like the 20th or 21st. And again, doing that lawyer math, if I did it right. And that would, so basically you're asking for a reset to May, is that right? Mr. Hidari, do you agree with that assessment?
For me, it makes a little difference if it's April or May, to be quite candid with Your Honor. So I'm okay with May.
Okay. Okay, well, that's what I will do. It is certainly my hope that the parties could figure out what to do with the case. Obviously, it depends on the court's ruling on the summary judgment motion, that the case continues to exist. And if it does, any insights into the number of witnesses or how long it might take you to actually try the case?
It's not going to be more than a one-day case, Your Honor, no matter what path we go on. If you rule in our favor, it'll just be a hearing on damages, which would have been liquidated by virtue of certain admissions. And so that'll be a short hearing. And if it actually goes into something longer, we probably would have about 4 witnesses on our side, but it wouldn't be lengthy witnesses, more people who would come in and just testify as far as the damages and repair and things of that nature.
Okay. And to that end, I will tell you that although I prefer to do trials in person, because it is a non-jury trial, it is certainly something that for the logistics we could work out if the parties could consent. I think the rule requires that y'all consent. But if the parties agreed, it's certainly something that we could probably accomplish by Zoom if that is more feasible, efficient, and financially responsible of all of us to do. So think about that since it is a non-jury setting. And I will let you know as well that, like I said, you'll get another notice of the same issue, and we'll have a pretrial conference, a more formal pretrial conference at that time when it's reset for May. Is there anything else that you need from me, Mr. Hidari?
Thank you, Your Honor. Appreciate it.
Mr. Johnson?
No, Your Honor. Thank you very much.
Okay, I will be looking at the motions, waiting for responses and other filings outlined by Mr. Johnson, and then I'll get y'all a ruling as quick as I can. Okay?
Thank you very much.
Sounds good. Thank you.
all. Have a good day.
You too.
Cajun Global versus Carolina Cafe. Who do I have here on behalf of Cajun Global?
Good morning, Your Honor. Lindsay Hunter for Cajun Global.
Okay. And I see Miss Reed.
Yes, Your Honor. I am trying to get rid of some technical difficulties.
Well, you have a lovely picture in the interim, so that's fine. It feels like I'm looking at you.
Thank you.
Are you able to participate and I just can't see you, or do you need a few minutes to work out whatever issue you're having?
No, Your Honor, I am able to participate and you can see me.
Oh, excellent. There you are. Okay.
I apologize. It was just a wire and that was it. Sorry about
Don't worry about it. The joys of technology.
Exactly.
So let me start by saying, Ms. Reed, I'm aware that you have filed a motion to withdraw from the case and that your client has consented to your withdrawal from the case, but I haven't actually allowed your withdrawal, so I very much appreciate your presence here. A lot of, you'd be surprised the frequency with which lawyers file a motion to withdraw, and then they think that just magically gets them out of the case. So I appreciate your presence here. I'm also aware that there was a motion in limine that was filed regarding the testimony of the principal versus a designated representative. Where are we on this case, though, if the defendants don't have counsel? Ms. Henner?
Your Honor,
Ms.
if
Reed?
I may, I continued the work. We got this done. Ms. Hannah was diligent with me. We've actually gotten the clients and ourselves to sign a consent judgment. that we would like to send to you, Your Honor.
Oh, thank you,
Um,
ladies, so much. I love that announcement.
Thank you. So at this point, my motion would be moved. Her motion
Okay.
to limit would be moved. And so we diligently worked last night and today to try to get this resolved. So we'll
Okay,
be sending
excellent.
that over shortly. My client just signed, as she's been a little sickly. My clients both, so they just signed, and I sent that over to Ms. Henner. So we should be able to get that to the court expeditiously.
Okay,
Yes, off the
excellent. So because it is a consent order that is at least that already exists and is at least partially already signed, there's no need for you to file a notice of settlement. I'll just be looking for that consent order to be filed sometime this week. Is that y'all's expectation as well, Ms. Henner?
Yes, Your Honor, we should be able to file it today. The only question that the parties had was whether you wanted a motion for entry of the consent judgment or whether just the proposed judgment is.
So you can just send the consent order, proposed consent order that's signed over by email to Mr. Freehoff, and then we'll sign it. Okay.
Great, thank you.
Thank you
Your Honor.
both. Have a good
May we
day.
be dismissed?
Yes, ma'am.
Thank you.
Breckenridge Station versus 3160 Millington Place.
Morning, Your Honor. Griffin Bell for the plaintiff.
Hi, Mr. Bell.
And David Messer for the defendant.
And
Hi,
Carrie
Mr.
Olson
Messer.
for the counterclaim defendant.
Ms. Olson, is that what you said?
Yes, ma'am.
Thank you. Hang on just 1 second. I'm going to take just like a 1 second break.
Sounds good.
Okay, I'm back. Sorry for that. Okay, so this matter is set on a non-jury trial calendar, and I have a scheduling order that was entered back in June of 24. And then, like I said, I know you guys may have been doing lots of things in the background. There's just not a lot of record activity. And then, now it's time for the case to be set for trial. Starting with Mr. Bell, what I did, by the way, thank you. I did receive the CPTO that y'all submitted. What is your position regarding what's going on and what the status of the case is, Mr. Bell?
Your Honor, it's pretty straightforward. I think we'd like to settle. In terms of the amount of money, we're not far apart, but I think it's the whole principle of the thing is getting in the way. And I think that we should just keep it on the trial calendar, ready to go. I think all parties would be ready to go today if we were to proceed today. So 2 weeks will be good then too. And maybe we can settle in the interim. I know there's been some discussions back and forth. Like I said, the money's not far apart, but it may be one of those where out of the principle, we all have to come back in front of you anyways.
Okay. Thank you, Mr. Bell. And Mr. Messer, what are your thoughts on that announcement, sir?
I would agree with every bit of that. Absolutely.
Okay. Ms. Olson?
I am in agreement with everything he just said. Yes, Your Honor.
Excellent. Look at all these lawyers getting along. Okay.
You're working on it.
Yeah. So I've got your CPTO, which is what I needed. I will, it is a non-jury trial, but I will go ahead and enter the CPTO to the extent that you guys still need a trial. The actual trial date we'll be in touch with you about what date it would be. But most likely it would be March the 24th, unless I have a jury trial that's going to bump it, because I would pick the jury on the 24th. But again, because it is a non-jury trial, we have a little bit more, fluidity and flexibility in terms of when we set it. I would expect that it would likely be in person, unless y'all tell me that it really works for y'all to do it by Zoom. How long are you thinking, Mr. Bell? To try the case?
I see it no more than 2 hours tops. I think we would have one, maybe two witnesses. Mr. Messer may have 1 or 2 witnesses. Again, in its essence, it's fairly simple. So I don't think it'd take up too much of your time. And I would prefer Zoom just simply for that brevity.
Okay.
Unless Mr. Messer or Ms. Olson have other opinions.
Okay. I don't want to put y'all on 2-hour call because I try not to do that because it's difficult for lawyers to manage. But for a non-jury trial that is as short as this one, I expect that it would be very easy for me to throw it on a Friday by Zoom. And so the reason I mention that is that if I'm not in a criminal trial, there's an outside chance that I might ask you guys to come in on I think it's the 20th or maybe the 21st of March, which would be that Friday right before the Monday jury trial. Would that be doable for the parties if I were to throw it on that date, Mr. Messer?
No, Your Honor, I'm going to be in Phoenix on the 21st.
Okay. Well, then what I will do is figure it out from there. If I don't have a civil trial that's going that week, then it would still be the 24th. But because it sounds like no more than one day with all of you, and that sounds like we can do it by Zoom. Although, as I said, I think the parties have to all agree to do it by Zoom for me to say it's by Zoom. So y'all continue to get along and let me know what you want to do. And then I will be in touch with a specific date. Any other conflicts or issues y'all want to let me know about for the week of the 24th that I might keep in mind when I'm sending out dates, Mr. Messer?
I think the week of the 24th, I'm good.
Okay. Mr. Bell?
I'm good, Your Honor.
Okay. And Ms. Olson?
I have a bunch of depositions, but I'll move them around for you. So no problem.
Excellent. I feel so special, Ms. Olson. Thank you.
If you want to do a Friday, that 28th is wide open for me. If that works for everybody else, just to put that idea out there.
I may very well do that as well, because it's likely that any other of these cases that may go to trial would be a jury plus, 2 or 3 days, and I might still have that Friday open. So I'll put tentatively a pin in March the 28th, but we will send you, it won't be probably a formal record setting. Like, I'm not going to enter anything on the docket, but we will email you and tell you what time to report and what day. Okay. And we'll send you a Zoom link and all that good stuff. Okay.
And Your Honor, I would agree with Mr. Bell. This is probably 2 or 3 hours.
Yes, sir.
So if it's the sort of thing that you need, as far as I'm concerned, that you need to put on a docket in terms of, while I'm waiting on the jury, I've got an hour sitting here, and we needed to do that in bits and pieces, I think we could probably pull that off. It's not terribly complex at all.
Okay, excellent. I appreciate that, because we do try to multitask, and sometimes we do that. So, okay. Well, thank you all very much. I will put you down tentatively for the 28th of March. We'll be in touch with a more firm setting and a Zoom link, unless anybody tells me different, and then we'll go from there, okay?
Great. Thank you so much.
Thank you all. Have a good day.
Thank you, Joe.
Okay, Fox Rothschild versus Roland Powell.
Good morning, Your Honor. Pat Dixon III on behalf of the defendant, Roland Powell.
Okay, and did I see Mr. Hi?
Yes, Your Honor. Good morning. Gerald Chichester on behalf of plaintiff Fox Rothschild.
Okay, thank you. Okay, so very short. So I must admit, Mr. Chichester, I was surprised by Fox Rothschild's opposition to the motion to open default, because Fox Rothschild had previously consented to it, and in fact not only agreed to it, but asked the court to waive the payment of costs by the defendant, which I advised y'all I can't do because jurisdictionally the court doesn't have jurisdiction if costs aren't paid to open default. And now y'all object. Can you get, I'm not inviting you to argue your motion. I've read the briefing, so I know what it is. But can you encapsulate that in about one or two sentences for me, Mr. Chichester?
Absolutely. Your Honor, it was when it was made clear to the defendant that the court costs had to be paid. I believe Your Honor's staff attorney and myself both urged defendant's counsel at the time, which I recognize is not Mr. Dixon, but it was prior counsel. But we did both urge prior counsel that the court costs had to be paid. Interestingly enough, in a very bullish way, she refused. and did not pay those costs until our motion for default judgment was filed after the court requested us to do so. So, Your Honor, it is troublesome and concerning, largely because of the court cost being a little less than $300, and the claim in our case is north of $90,000. The refusal to pay those court costs to her client's own benefit was concerning, and it kind of, at the very least, sparked an internal conversation as to whether or not the case could be settled, which is our goal, is to get it resolved.
I know. Generally, lawyers really don't want to fight clients. I get it. Thank you. Forgive me for cutting you off, but I'm going to ask Mr. Dixon same question, sort of 2 or 3 sentences, if you can, Mr. Dixon.
Well, Judge, I can't really speak for previous counsel. I know that it was my conversations with her it was her position that the plaintiffs were the ones who actually caused all the confusion with the service of the complaint and paying the costs. And so there was some going back and forth in terms of who was going to pay the costs. Since then, we came in kind of on the, a couple hours after the plaintiff filed their motion. We came in, we paid costs, we filed an answer, we filed an affidavit, we announced ready. And
right, because you know what you're supposed to do when you respond to a motion to open default, Mr. Dixon.
Exactly, Your Honor. And so the previous counsel, sir, quite frankly, Your Honor, my client's an entertainer. His previous counsel is an entertainment attorney, doesn't really delve into this area. I would hate for, Mr. Powell to get the brunt of that. But
forgive me for cutting you off, Mr. Dixon. But as I said, I have read the motions, and I was aware of the background. The only thing that made this somewhat interesting was this. I never had a situation where the parties. I've certainly had parties consent to open default, especially where it's pretty clear there's no prejudice. Not a whole lot of time's gone by. It's probably likely the court's going to open default. What I've not had is somebody say, "Hey, please don't make us pay costs." So, as I said, my understanding of the law is that is a jurisdictional condition precedent, and that I don't have jurisdiction to open the default if costs aren't paid. Having said all of that, Mr. Chichester and Mr. Dixon, I have read the motions, as I think I just telegraphed pretty clearly. Costs, all the statutory prerequisites that are necessary to open default have occurred. And the only real issue is whether or not the defendant had established a proper case, excusable neglect, or providential cause. And while I appreciate Fox Rothschild's point about whether they've established, one of those things, at the end of the day, the language of proper case is pretty broad. It literally says it's a situation where the court can reach out and grab any feasible basis to open the default. And here, Mr. Chichester, at the end of the day, while I understand, I don't mean to penalize Fox Rothschild for attempting to be reasonable at the beginning of this process, but it is a little odd that y'all would have agreed to open the default and then changed your mind about it. And I hope that ultimately, given that Georgia has an express preference for consideration of cases on the merits and not by default, that the parties can get back to where they need to be with Mr. Dixon and Mr. Chichester trying to resolve the case to the extent that it can be resolved, or otherwise preparing the case for trial. So I'm going to deny the plaintiff's motion for default judgment, and I'm going to grant the defendant's motion to open the default. Mr. Dixon, can you send me just it doesn't need to be any big, long thing, but if you could send me a proposed order that does both of those things?
Of course, Your Honor. I get that.
If you can email that in Word format to Mr. Freehoff, then I'll have an ability to edit it. And then what I will do, now that issue has been resolved, I don't know if you guys are familiar with my standing order, but on the website where my name is on the Fulton County website, there's a template scheduling order. And so now that the case is sort of ripe, and I'll enter that order on the default, the parties need to enter into a scheduling order. Y'all can pick whatever dates you want. If you don't pick any dates, then I'll pick some for you. That way we'll all know when you can anticipate going to trial, or in advance of that, if there's going to be dispositive motion practice, and then y'all can see what efforts you can make to resolve the case or prepare it for trial. Any questions, issues, Mr. Chichester?
No, Your Honor.
Okay, Mr. Dixon?
Nothing from us, Your Honor. Thank you so much.
Okay, excellent. I hope both of you have a good day. I'll look for your proposed scheduling order in Word format sent to Mr. Freehoff. And also, Mr. Dixon, I'll look for the proposed order on the rulings I've just made, okay?
Thank you, Judge.
Thank you all. Have a good day. Okay, and that takes me back to Ms. Timberlake. I see that Ms. Ann and Mary Timberlake have joined us. And then before I get to that one, Ms. Meadows, if you'll be a little bit more patient with me, Mr. Mzikawe, Mr. Pugh. Okay, so I am aware that there is a motion to dismiss pending regarding Craig Miller, asserting lack of service. I'm also aware that although there may be time, I haven't done the math exactly, there may be time for Marlin's Plumbing to open default. Cool Runnings, I think, is definitely in default. I think Marlin's Plumbing is also probably in default, and I haven't done the math to figure out if there's still time for one of them, for either or both of them to open the default. Mr. Johnson filed a special answer and then a motion to dismiss regarding the service of process. But the time for the, I guess, Mr. Pugh to respond to that has not yet is not yet ripe. Meanwhile, if you'll forgive my frustration, this case is a significant point of frustration for me because it seems as if it is just a moving target. All the parties seem to be, I mean, this is not the first round we've had with Cool Runnings, Marlin's Plumbing, and Craig Johnson. Meanwhile, I'm a little frustrated that while certainly I understand and the need for proper service on a party, it is especially frustrating relative to Mr. Johnson, who I think there's really no dispute that he's aware that this case exists. And so I don't understand why we're still having these disputes. And I don't mean to imply that that's only frustration with Mr. Mzikawe, because, for example, Mr. Pugh, we could have been having this conversation 3 months ago if somebody had timely filed proof of service, where I mean, the proof of service, my review of the affidavit of service indicates that Mr. Johnson was allegedly served in November of 24, but proof of that service wasn't filed until late January. So I'm a little miffed with both of you, no offense, right? But like, what are we going to do? What are we going to do to get this case back moving and figure out what to do with them? Mr. Pugh?
Your Honor, and if I could talk about the proof of service for a second. Our process server, they alleged to have served Craig Johnson's mother-in-law. That's what they said she had identified herself as. Now, I understand that there's a motion to dismiss that disputes that fact. So but the process server, there's a picture of her being served. So we have.
Well, hang on. Forgive me for interrupting, Mr. Pugh, but that wasn't actually an invitation for you to argue the motion per se. It was more about, what are we going to do with this case procedurally, where I've still got an unripe motion to dismiss based on personal service, but I've also got the parties saying they weren't properly served, Mr. Mzikawe, is somebody who's clearly known about this case for better than a year. So really my question is not necessarily to get into the meat of that motion to dismiss, because as I said, it's not right. You haven't had a chance to argue it. I think you're entitled to have a chance to argue it. But really more, how do I reconcile that with, I think this is not the first motion for trial date. How do I reconcile that and figure out what to do with this case, Mr. Pugh?
Yes, Your Honor. I think that your calculation of the defaults is correct with regards to Marlins and Cool Runnings. We had Marlins answer calendared as being due yesterday. So this might be a case that we have two parties in default. With regards to Mr. Johnson, we've tried, I believe, 3 addresses at this point several times. Our process server didn't send us that proof of service until last month when we followed up
So,
and asked what's going on.
I understand that, Mr. Pugh, and again, I'm sorry to interrupt. Again, I don't mean to pick on you, Mr. Mzikawe, but here's where the court gets frustrated. Service is not a game. And while I appreciate, Mr. Pugh, that you've made efforts at multiple addresses, you know what nobody's done? Asked anybody to waive service or acknowledge service.
We have,
Mr.
Judge.
Johnson, well, did they? And if they refused, then why haven't you asked me to make them pay attorney's fees? I mean, there are lots of tools I have at my disposal when people are potentially being deliberately obstructive to the process of moving a case forward. And so I'm just throwing that out there. Service is not a game, right? The purpose of service is just to make sure that people know. And while Mr. Mzikawe, your client is absolutely entitled to legally be provided with proper service, whether he was or not is not the issue for me right now. At the end of the day, when that person has a lawyer who is in the case, it is very frustrating to the court that Mr. Pugh is spending a lot of money and a lot of time to get someone legally properly served who will not accept service, which I can't make him do, and who I'm sure Mr. Pugh would argue is deliberately making it difficult, particularly when that person is represented by a lawyer who is representing other parties in the case. That's just my rant for the day. Mr. Pugh, I've interrupted you a couple of times. I'm sorry. Did you have anything else you wanted to add before I call on Mr. Mzikawe to defend his good name? And I don't mean to cast aspersions on anyone. I really don't. Go ahead, Mr. Pugh.
Yes, Judge, we have asked for service to be acknowledged several times. I understand Mr. Johnson's right is to not consent to that. I would like to point out that we still have our motion to amend the scheduling order and allow service by publication. We believed was rendered moot when we filed our affidavits of service, but technically is still pending, Judge. So if the court would like, we would like that motion to be ruled upon. If it's found that Mr. Johnson is evading service or that service has become impractical, we would like to perfect service by publication as well.
Understood. Mr. Mzikawe.
My client is not avoiding service. And then secondly, I think to the courts, well, let me back up. With respect to the scheduling, I think that we are ready to go to trial. We are ready to go to trial in March. If that's the court's idea about starting to go to trial. With respect to my client is not evading service. They went to a certain address that my client doesn't live at. And I also note for the court that we have a pending issue with service on Ms. Padone, who is an original defendant. And they initially said they would not sign an acknowledgement of service that we asked for. And so that has been an issue also. But I think that with regards to our filings, we essentially stand by our filings based on process.
Okay. Again, I can't make anybody accept service, but I can lecture everybody about service not being a game.
Judge, if I may, with regards to Padone,
yes,
I understand previous counsel might have been asked to acknowledge service and declined. We have been asked to acknowledge service one time, and we said that we would. If Mr. Mzikawe would acknowledge service for Craig Johnson, absolutely. We responded immediately. That was over 2 months ago, and we didn't get a response.
Okay.
So we've been asked once, and we've consented, and the conversation died, and we followed up.
So the next question I have is really more to the substance of the case, because again, everybody's entitled to their day in court. Everybody's entitled to fully adjudicate legal disputes. But at the end of the day, this doesn't seem, for all of its procedural complications, it doesn't seem like that complicated or that expensive or that involved of an actual legal dispute. I mean, it's essentially a you didn't pay us for work we did, and a defense of your work was crappy, right? I mean, those are fairly standard cases that we see all the time, and it just doesn't typically involve this much back and forth. And so, Mr. Pugh, to Mr. Mzikewe's point, setting aside the very obvious concern about the court having the proper parties in front of it, through attachment by service, et cetera, Mr. Mzikewe's announcement is that his clients are prepared to go to trial. What about your clients?
Well, Judge, with respect to Mr. Mzikewe, I would probably announce that I was ready to go to trial if one of my clients who the other party had been trying to add to the case had, in my mind, not been properly served as well. I mean, there's a client that filed a lien against Brixel in his personal name, not in the name of his company. That's Craig Johnson. And he filed a lien against our company for exactly what's at the heart of this litigation. I don't see a way that we proceed without him. And we have, Cool Runnings and Marlin's General Plumbing as well that are involved, that were subcontractors that are claiming to have been shorted by Boy Wonder. I mean, there are parties that have now been served, with the potential exception of Mr. Johnson, that I believe were necessary to the case. If they're in default, we'd like to proceed and file, motions for default as soon as we can and get that process going. But if they plan to, come into the case and open default, then we would defer to the court on what kind of discovery process they would, be able to enjoy. But that would be our position, Judge. I mean, we think that there's two parties. There's one party that still has time to open their default. There's another one that we would be seeking to enforce a default on. And then there's a party who has a lien on my client's property that's at the heart of this case, who we haven't been able to add, who's aware of the case.
And that's Mr. Johnson, correct?
Yes. Yes.
Okay. So here are a couple of questions that I have. Mr. Pugh, the motion to dismiss based on service was filed on February the 26th.
Mhm.
How soon are you able to respond to that motion? Technically, your response would not be due until approximately April 1st-ish. Again, I'm not looking at a calendar, I'm just estimating, but
Judge, I'm sorry, I was just making sure I had the same date down. I could have a response to you. We've got a trial calendar that we're on starting the 17th, but I could have you a response. I could try to have you a response before then. I believe it'll be simple. Ours, if it happens that the woman that we served was not related to Mr. Mzikewe, then it's quite possible that service was not proper, and we're going to have to try a different route. Which, Judge, we're fine with. If the court wants to look back at our motion to allow service by publication as well, I think that would allow us to proceed in the quickest manner at this point. And we'd also be willing to accept an acknowledgement of service if that's on the table, obviously.
okay. Well, I will just remind Mr. Mzikewe so that you can remind your client, because obviously you can't make your client agree to anything either. But I always, even assuming that he is not evading service as you have represented, if in fact Mr. Pugh has made a formal request to waive service, Mr. Johnson should understand that if service is ultimately secured and the court is persuaded that Mr. Johnson was being deliberately evasive, then there is a universe in which the court can award fees to Mr. Pugh, costs, I should say, to Mr. Pugh and against Mr. Johnson individually for the costs associated with trying to secure service on him. If a proper waiver was filed, there are lots of ifs there. If a proper request for waiver, request for acknowledgement was filed, if the party that did so is successful in proving that Mr. Johnson was in fact attempting to deliberately waive, et cetera. I mean, those are all ifs, but that's always, to me, something that's important to make sure Mr. Johnson understands. Here's what I would like, Mr. Pugh, is by, it sounded like you were saying by the 14th that you have a trial going out on the 17th and that you would be able to do something before then. That's obviously before the statutory deadline. I have the authority to give you a shorter deadline. I'm not going to do it unless you say it's doable. But here's why I want to know the answer. If I'm going to deny the motion to dismiss, then Mr. Johnson has been attached and he has filed a special answer. And then we can have a conversation about, and by then we would know if Cool Runnings and Marlin's Plumbing were in default irretrievably or had moved to open default at that point. And so then we might have a more practical idea of how and when to schedule this case. Now, it is set for a jury trial, and I did notice there was a pretty significant difference in how long the two parties expected it might take to try the case. What is the difference from your perspective? Was it Mr. Pugh? Were you the one that said 3 to 5 days, or one of you said 3 to 5 and one of you said like 4 to 7, I think is what it was.
I think we said 2 to 3 days. I could be wrong.
Yes, Judge. And we only said 4 to 5 because of it was difficult for us to put together the pretrial order, given that, at the time that we were consolidating, there was still a party whose answer was due. We weren't sure what they were going to say. We would rather the court go in thinking 4 to 5 days and it take 2 to 3 than
Sure.
vice versa.
Always
we
better.
just always want to be
Yeah,
sure
especially
not to
with a
underestimate.
jury, always better to under promise than over deliver, right? So, but it sounds like realistically, we're probably somewhere in maybe the 3 to 4 day range, with the idea that once we get in there in front of the jury, it may go a little faster. Okay. That's a long time for as I said, no, I don't mean to discount the ins and outs of your client's respective legal positions, but at the end of the day, this is we did work, they didn't pay us, and the defense is the work was not good. And so that just seems a lot more straightforward than 3 to 4 days, but I don't know your case as well as you do. In any event, right now, here's what I'm going to do. I'm going to put it on my April trial calendar. I'm going to move it to April, with the idea that we will have a better understanding. And by the way, Mr. Pugh, as I was deciding to move it to April, that would put the pretrial conference usually about I think it's the first week of April, that week of April the 1st. And then it would, similar to this month for March, it would be set for trial that sort of probably last week of April. And so the question then is, if I do that way, do you want to have your full time to respond to the motion to dismiss regarding Mr. Johnson?
Your Honor, we understand that the court's frustrated with this case. We will try to have a response before that March 17th trial that we're handling, just to try to speed things along. And we're really interested to figure out the status of the default. So once one party might be in irreversible default in 14 days. So that, if that's the case, that probably expedites things as well.
So my calculation is that Cool Runnings was served on January the 26th. Their answer would have been due on February the 25th. And then 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. I have them as being in default, effective, irretrievably in default, unable to open as a matter of right as of March the 11th. And then Marlin's was served on February the 3rd. So I think your math is right, that they would be, that they would have just gone into default probably yesterday or maybe the day before, on Monday, I think. But maybe not. Maybe it was a little bit further. But regardless, they've still, as you said, got about 15 days before they are irretrievably in default. Okay. So what I'm going to do then is move this to the April trial calendar, which will give us the benefit of knowing if these individual parties are going to be in default or not. And then will give us time to resolve the issue of Mr. Johnson's service and whether he is a proper party. To be clear, Mr. Imzikwe, to Mr. Pugh's point, it sounds as if I have two issues to look at regarding Mr. Johnson's service. One is whether or not this was proper service or whether your motion to dismiss is subject to being granted. The second one is to consider the motion to serve by publication, which requires me to consider whether or not Mr. Johnson has been evading service. And if I found that he was, then I would authorize service by publication. And we'll go from there. Again, I cannot make any of your clients agree to be served. They are absolutely entitled to proper legal service. But I will tell you that when efforts like this are made consistently and service is subsequently secured and a party makes a motion, I am typically very sympathetic to costs motions in that regard, because it does feel, if it's demonstrated that someone's being deliberately evasive. Again, I understand your position, Mr. Mzikawe, that Mr. Johnson's not being deliberately evasive, and I may find that he is not once I have a chance to look at that motion. But I'm just throwing that out there as just so you know what my predispositions are on that issue. Okay. Do you have anything to add? Any concerns? I know you said you were ready in March. But understanding that it would be an April trial date and that we would send you another notice. Any other questions or concerns, Mr. Mzikawe?
Well, with the issue, I guess with the idea that my client would be in the case, then he would file, of course, a proper he would file a proper answer, a follow-up answer. And I'm not sure about this. I'm not sure about discovery from that vantage point, from his individual vantage point. But I do believe, and counsel can, he can correct me, but I think that they asked for additional discovery time for that purpose. But
right, there is a motion for, yeah, I'm sorry, I didn't mean to interrupt you. Yeah, you're right. There is a motion for amended scheduling order.
Yes, and that's the same motion where we asked to allow.
That's what I thought.
Yeah.
I'm sorry, that's the same motion. What, Mr. Pugh?
It's the same motion. It's a motion to amend the scheduling order and allow for service by publication.
Okay. I knew they were filed contemporaneously. I didn't know they were filed it's the same motion.
Yes.
So I think Mr. Pugh's point is a valid one, which is the extent to which the court needs to decide whatever we're going to do if the parties get additional time to conduct discovery. And one conversation we'd need to have realistically, Mr. Mzikawe, is that if Mr. Johnson is in fact your client and is in fact a principal or someone directly involved, which my understanding is the allegation is that he is, because he was either acting on his own or on behalf of Boy Wonder when he filed this lien. The idea that I would need to delay this case so that your client, Mr. Johnson, could individually conduct the exact same discovery that your client, Boy Wonder, would have been under an obligation to conduct, probably not one that's going to win the day. And so y'all should be prepared for that. And if we are going to, I'm going to go look at the motion for amended scheduling order now. And the only thing I will say is that I think my standing order says you need to tell me what discovery you've actually already conducted and what discovery you really still need to conduct. And assuming that's there, then I will consider it. But that's sort of where we are. Anything else to add, Mr. Pugh?
No, that covers everything from our end. Thank you, Judge.
Anything else, Mr. Mzikawe?
Yeah, thank you.
Okay, well, hang on. One last thing I do want to say is I did say I was going to reset the case for April. I'm going to tell you now that there's one or the other things are going to happen. You're either going to get a reset notice for April, or you might get an amended scheduling order. And if you get an amended scheduling order, then that will tell you when you are set to go to trial. Do you understand? Okay, excellent. Thank you both for your time and your patience this morning and walking me through the procedural stuff in your case. I appreciate it, and I will see you guys again soon, okay?
Thank you, Judge. And one more thing I'd like to leave
Yes, sir.
you. When you read our motion, and look through it, There's been some slight developments that we've talked about today. If you'd like us to rebrief and supplement, we're happy to do so. If we end up doing that, we're happy with allowing Mr. Mzikawe time to respond to any supplemental briefing that we do. Just we'll be on standby for that.
Well, if what you mean are you talking about developments associated with the motion to serve by publication, or are you talking about developments associated with the scheduling order?
Just with regards to the service of Mr. Johnson. And so
Okay.
we discussed most of it today. It's really just the proof of service that was filed and the allegations around that.
Well, that sounds like what you'll be putting in your response to the motion to dismiss. And I think that's probably the appropriate procedural vehicle for the court to consider that. Okay.
Sounds good. Thank you, Judge.
Okay. Excellent. Thank you both. Have a good day.
Thank you.
And Ms. Meadows and Ms. Timberlakes, if y'all can give me just like 2 minutes to grab some more coffee, I will be right with you. Okay.
Sure, no problem.
Thank you.
Thank you.
Okay. Good morning. So here is where we are, at least from my understanding. Well, let me ask. So the last contact I had, and that's the announcement I made to Ms. Meadows, I think we had copied her on that communication, but just to make sure she was aware of it, it was right before you got here, was that y'all had notified Mr. Freehoff that you'd had some that you had some concerns about whether you had everything from your lawyer. And so we, as I had told you I would do in the hearing that we had, the discovery conference we had previously, we reached out to your prior counsel and he indicated that he had given you everything that he had emailed you. And I understand that that is frustrating and that you may disagree with that announcement, but I don't know that there's any way for me to do anything about it other than accept his representation, which in his defense, I'm hoping that making such a representation to a judge carries with it perhaps some more indication of him credibility in terms of perhaps what he might represent to clients or otherwise. So having said all of that, where we are is that the reason you wanted those files was so you could try to retain counsel, but I think been pretty clear in the last hearing that we had that you needed to appear for your deposition, which my understanding is that you have. And then the purpose of today's hearing was the defendants had requested oral argument on the motion for partial summary judgment that they filed, seeking to dismiss all of the claims except count 2. There might be some habitability claims that would continue to exist without personal injury claims. And so that's what I understand the motion for summary judgment to be. So with that background, so we're all sort of on the same page, Ms. Timberlake, whichever one of you, can you tell me, one, have you been able to retain counsel? And 2, what is your position on the case and what we need to do with it or what we can do with it today?
So we're looking for another attorney. I'm waiting on a call back from legal aid. There's a bit of confusion because in our contract it said that if he wasn't going to be our lawyer anymore, then he was going to find his replacement. And so you requested him to give us those documents, and he did end up giving us our documents later that day, or was it like it was that, the same day. And we realized that they were incomplete. I spoke with Lauren yesterday at our deposition, and we realized that the documents that she had received definitely didn't match up what we had believed their side to receive. So I'm in the middle of compiling all of the documents, and we spoke about what she would like yesterday. And so I'll have all of those to her by the end of day. I'm still on the hunt to find replacement counsel. But we did get the depositions accomplished yesterday.
Okay. Thank you, Ms. Timberlake. Ms. Meadows, what are your thoughts about where we are and what would be our next step?
Sure. So I do appreciate both Anne and Mary for coming yesterday to the depositions. That it was a long day, but we got them taken care of. So I appreciate both of them doing that. I kind of see it as 2 separate issues. So the motion for partial summary judgment was my attempt to clean up the pleadings a bit. I felt like the complaint included a lot of causes of action that either weren't legally sound or could clearly be eliminated, to where we could narrow this down to what truly was the true issue of the case. And as I see it, the true issue of the case is the one that I did not move for summary judgment on, which is the warranty of habitability as it relates to the property damage. So I was not going to include that claim because I think there might be some questions of fact in that claim. So I wasn't going to bring it before the court and waste everyone's time. But I did file a motion on what I felt like were the claims that either could be resolved strictly on the law or on the undisputed facts. That motion was filed on December 18th, I believe, long before their prior counsel withdrew. The time for their response was, again, long before their prior counsel withdrew, and no response was filed to the motion. I understand that you can't win a summary judgment motion by default, but there has been no counter arguments and nothing to even suggest that these aren't legal issues that the court can resolve as a matter of law, which I feel that they are. So that was my goal, to just let's get the case down to what actually is the issue here, which I think is the warranty of habitability on the property claim. That being said, So I think independent of everything that Ann just mentioned about documents still being needed to have some exchange of discovery, I think that we can narrow the case down to this one remaining claim. And then I also spoke with both ladies yesterday a good bit about where do we go from here? What do we do? How do we resolve this? I recognize that you don't have counsel, and one thought that I had, we actually mediated this case back in October when they were represented by counsel. We did not reach a settlement then. But I thought, well, maybe it's worth mediating again. I reached out to the prior mediator that we had used in October to gauge her comfortability with doing another mediation with them now being pro se. I spoke with her last night. She indicated that she would be comfortable doing such a thing. She wanted to be clear that she was not representing anyone. She would be serving as a neutral mediator. But I do think that there is some potential resolution that we can get as it would relate to the one remaining claim that that plaintiffs have asserted. In addition to plaintiffs' affirmative claims, we have a counterclaim for unpaid rent with regards to the rental property as well. So my goal is to wrap all of that up, hopefully in a mediation. But again, my thought is it's kind of two separate issues. The reason that we're here today is the hearing on the motion. That's really an undisputed motion. I think that we can narrow it down to just being the one remaining claim, and then we can either mediate that claim or exchange more discovery as we need to with respect to that claim.
I understand, Ms. Meadows. Thank you. Ms. Timberlake, what any response, any request in terms of what the court, what Ms. Meadows has just said, and most importantly, what the court should do with the motion for summary judgment that Ms. Meadows correctly points out, and we talked about it the last time we met, was filed and pending when you still had counsel, and no response was filed. And if the court were to grant the motion in its entirety, then what that would mean is that what you would still have is a disputed case regarding the habitability of the property in which you resided, and what damages flowed from that in terms of property damage, et cetera, associated with claims that the property was not habitable. And then apparently Ms. Meadows says there's a counterclaim for unpaid rent. And then also this idea of a continued mediation. What are your thoughts?
I think I just need some, and appreciate y'all's patience with us this morning. There was some confusion again with the date today and what that meant. And I apologize, Your Honor, for us being tardy. I think I need some clarification of what all this means, since our counsel obviously did not explain what this hearing was about or that we should be here. Dropping one part, can you help me understand what that means about dropping one part of it, the summary judgment?
I'm sorry, Ms. Ann Timberlake, did you, I normally never ever refer to a party. I think I said this last time by their given name, but just to keep it straight. Ann, did you say something else I wanted to hear before I respond?
Yeah, I think that there was a lack of communication between not only our attorney and Lauren, but our attorney and us as well, because as you're talking about, things that went like with, no response, we were unaware of that, that we were lacking any participation at all, and kind of looked at deadlines with Lauren yesterday and realized that I wasn't like being, told these things were going on. He was just kind of, doing the lawyer thing without us that involved. So it's kind of switching to being more involved, obviously.
And I understand that, and I'm very sorry for you having that experience. I do want to be clear, though, that ultimately, as I told you last time, number one, I'm not supposed to treat you any differently when you have a lawyer versus when you don't. And number two, the extent to which those things might have compromised your legal position in this case, that is also not an issue that is before me. So I just want to make sure you understand that all I can do is sort of address what's in front of me. And Ms. Meadows has correctly stated the procedural posture of the case, which is that There was a motion for summary judgment that was filed and your lawyer did not respond to it. Now, Ms. Meadows is also right that I can't grant it by default in the sense that it's not just you lose because you didn't answer. The court still has to look at what the merits of the case are. And that's, to your point, Mary, is as uncomplicated as I can make it, and it's probably still complicated because, you know, it is what it is. You guys asserted 5 causes of action against the defendant in this case. One was a claim for breach of contract. The defendants have asserted in their motion for summary judgment that you don't have an actual actionable claim for breach of contract because the things that you are complaining about either were not terms of the contract to which you agreed or were known to you at the time that you entered into the contract. For example, the fact that it was a 2-bedroom or whatever, right? And number, I'm going to skip over quiet enjoyment for a moment. You've also asserted, habitability. Your complaint also asserts a claim for quiet enjoyment, which is a legal concept that says if I'm in possession of a property or have title to the property, I'm entitled to not have anybody interfere with my enjoyment. And the defendant has asserted a defense saying that legally, in order to make a claim for quiet enjoyment, you have to have primary title. You have to have the highest level of title that's not that where someone else doesn't have higher title than you do, paramount title. And her argument is that you do not, because of course, Mr. Lefkowitz owns the property, and you were possessing it pursuant to a lease. Number 4, you had asserted a claim for unjust enrichment, which is a legal claim that is basically an alternative to a contract, right? It says this person has been unjustly enriched by something in the absence of a contract. And the defendants have come forth and said, well, you can't have both those claims legally. If there's a contract, there's a contract. And if there's not a contract, then you can assert unjust enrichment. But clearly, your complaint says there's the lease contract, and that bound the agreement between the parties. And then there's a claim for attorney's fees, which generally there would be an argument that if all the claims go away, then there would be no claim for attorney's fees. And the other argument is there's something called a bona fide controversy, where if the parties have a bona fide disagreement, then one party can't be held responsible for the other party's attorney's fees. That's the basis to dismiss counts 1, 3, 4, and 5 of your case. Now, separately, your lawyer asserted on your behalf a breach of the warranty of habitability. And what the defendants have sought to dismiss is that claim, it says that the home was not habitable and that the lack of habitability caused damages to you. And I believe the complaint may or may not allege that that caused both property damage and potential alleged personal injury. The real issue for that matter, as Ms. Meadows pointed out a moment ago, and if I'm going to give you a chance to correct anything I've said, Ms. Meadows, but I have read the motions and looked at the issues. So, is Ms. Meadows' position on behalf of the defendant is that Georgia law requires that if you're going to file a personal injury claim associated particularly with these types of claims, where you're maybe talking about lead or mold or anything like that, you are required to have an expert who says this is a thing that really exists and it really did cause this thing, this personal injury that's alleged, in order to create an issue of fact that would need to be tried by a jury. And given that discovery is closed and that no such affidavit exists or has been filed into the record, the defendant's position is that to the extent you've asserted personal injury claims, those claims should be dismissed because there's no expert to say that they are to create an issue of fact. And so what that would leave you with, to what Ms. Meadows said a moment ago, is you would still have a claim for habitability, that the property, a disputed fact to be tried by a jury that the property wasn't habitable. And the damages at issue would be any property damages or other issues that arose resulting from that alleged lack of habitability. That was a whole lot that I just threw at you, but I tried to make it as straightforward as I could. Does that generally make sense?
It
Yes,
does.
ma'am.
Thank you so much. I just needed clarity of what Lauren was saying about what this this hearing that we're on right now meant and, dropping what part and all that kind of stuff. So thank you, Judge. I appreciate it.
And that was a very thorough explanation. I have nothing to clarify on my end.
Okay, well, I try to do my homework before I show up for a hearing, so, okay. So then what really, now that we sort of all understand, where we are, the next question is we still need, even if I grant the motion in its entirety, Ms. Meadows, which I'm not saying I will, but even if I did, we still need to have a trial. Because there is still an issue, at a minimum, as to that warranty, that habitability claim. And so what I guess my question is what concerns do you have if we were, well, this is a question about timing. I'm not asking it very clearly, but right now this case is on a trial calendar for March the 24th, which I'm happy to make it go. But I also, if the parties are considering an opportunity to meaningfully mediate or continue a mediation with a mediator, and then also the Timberlakes are potentially attempting to retain counsel, if nothing else, to represent them at a trial. Procedurally, time-wise, what are your thoughts, Ms. Meadows?
Just to clarify, Your Honor, this one's actually not on it's a June calendar, so we still have a bit of time.
Okay. Sorry, I had pretrial in my brain because that's what I've been doing all morning. So I apologize.
No. But I think to your point, with the June calendar, I believe that we would have time to have conversations amongst ourselves, potentially mediate this a second time, well before your June pretrial conference date. And if necessary, come June, we could let you know if we are requesting more time. But I certainly don't want to extend this unnecessarily. And I say June because that's the day. I'm not suggesting that we wait until June to have these conversations. I mean, I think everyone would like to have these conversations this month, in the next couple of weeks. So like I said, I contacted the mediator last night following the conclusion of Mary's deposition. So I think just getting, my clients on board, we should hopefully have a second mediation in the next 2 weeks before the end of March.
Okay. Ms. Timberlake, either Ann or Mary, what do you think about that timing?
I think that's a good plan. I mean, I was worried when you said March 26th, but I think that just like, oh my gosh.
Okay.
And I think yesterday was very productive, and Ms. Meadows was very professional, and I think this plan, I think we all want to be on the same page. I think we all have the same goal. But just get make sure Ms. Meadows has all the facts and all the files that we have. And then if we go back to mediation, then maybe we can get this settled and not tie up your court.
Okay. So here's what I am going to do. As I said, the motion for partial summary judgment, no response was filed. I understand that y'all are without counsel now. And if your counsel wants to, if you are able to retain counsel and they want to revisit some of these issues, then we'll cross that bridge when we come to it. But as I mentioned, I did take some time to review the motion for partial summary judgment. And I think that Ms. Meadows is almost all the way right, but not all the way right. And so what I'm going to do is, I think Ms. Meadows is right about the personal injury claims and the warranty of habitability. I think that Ms. Meadows is right on count 3 for quiet enjoyment. I think Ms. Meadows is right on count 4 for unjust enrichment. And I think Ms. Meadows is probably right about the breach of contract, but that's squishy enough without hearing from an attorney about what were the material terms and all that good stuff and what was known or not known, that I think I would be more comfortable leaving that open for now. And so all of that's a long way of saying this. Ms. Meadows, I'm granting your motion for partial summary judgment to grant summary judgment to the defendants on the personal injury claims that are encapsulated in count 2, to the quiet enjoyment claim in count 3, and the unjust enrichment claim in count 4. I am denying the motion for summary judgment on count 1 because of issues of materiality. And I am denying the motion on count 5 because 1, an underlying claim continues to exist, and 2, the bona fide controversy issue really is an issue of background facts that I really would need to hear. And so if you, Ms. Meadows, could provide me, if that's possible, with a proposed order that does that, then what that means going forward, Ms. Timberlake and Ann and Mary, if as you are talking to attorneys, what you would need to let them know is that what you still have pending is a breach of contract claim associated with the lease. You have a warranty of habitability claim associated with property damage that you might have experienced allegedly, and you have a potential claim for attorney's fees for bad faith or that sort of thing, which is counts 1, 2, and 5 of your complaint. Ms. Meadows, does that make sense in terms of what my ruling is?
It does. The only, I guess, question I have is on count 1, the breach of contract. We had included a footnote in that argument, which also said, just to the extent plaintiffs allege personal injuries with respect to count 1's breach of contract, the personal injuries claims fail as well for that same reason as count 2.
Yeah, and if you want, and I typically tie it to the counts, but if you want as a separate point head to just talk about the fact that a personal injury claim of this nature must be supported by expert testimony, and if it's not, it can't survive, then you can frame it that way, because I agree with you that that would be the same ruling for count 1 as well as count 2.
Just so I understand, you're denying as to count 1, the breach of contract still exists, but we are on the same page about to the extent that there's personal injuries arising from breach of contract.
Yes, that's correct. Okay. Any questions about that ruling? Does everybody sort of have a general understanding of what I've said and what you should tell people as you're going forward? Then the next time I will see y'all, unless there's any issue that y'all need to bring to my attention, will be, hopefully I'll hear maybe that you've resolved the case through a settlement. Otherwise, you'll get a notice of placement on the trial calendar, probably about a month out. And you will come in for a pretrial conference like the ones you saw happen this morning in the first week of June. And then the case would be pulled in for trial in probably the last week of June. Okay.
Okay.
Anything else? Does anybody need anything else from me, Ms. Meadows?
Nothing for me, Your Honor.
Anything else, Mary or Ann?
Nothing for me.
No, thank you for your time.
Okay. Thank you very much for your patience with me this morning and getting through all that stuff. I hope you have a great day, and I will get my order on file, and then I will see you guys in June if necessary. Okay.